Okay, let's get right into it. We're going to tackle a really fascinating legal puzzle, one that affects millions of us in today's workforce. You know that fuzzy line between being an employee and an independent contractor? It can get super blurry, but man, the difference is huge when it comes to your rights, your benefits, and your legal protections. So, how do the courts actually crack this code?
So at its core, the law basically puts work into two different buckets. You've got the contract of service, that's when you're an employee, or what the law sometimes calls a workman, and then there's the contract for service, which makes you an independent contractor. Looks simple enough on the surface, right? One gets legal protections, the other not so much.
But what happens when things get messy? When that job title just doesn't tell the whole story? I mean, say you're hired as a consultant and you sign a consultancy agreement. Does that automatically mean you're not an employee? Well, the courts say, hang on a second, not so fast.
To get to the bottom of it, courts in Sri Lanka have this really cool judicial toolkit, basically 4 key tests they use. These tests help them look right past the fancy labels on a contract to figure out what the working relationship really is. So let's break them down.
All right, first up in the toolkit is the classic control test. This one's the OG, the oldest test in the book, and it boils down to one simple question. Who's really in charge? If a company has the power to tell you not just what to do, but how to do it, well, that's a massive clue that you're probably an employee.
Next, we've got the integration test. This one's all about how essential your job is to the main business. Think about it. Are you totally woven into the fabric of the company, like a key part of the operation? Or are you more of an accessory, someone who just provides a service on the side?
Okay, then there's the economic reality test. And this is where things get really practical, because it's all about following the money. It asks, who's actually taking the financial risk? Who's buying the tools? Who gets the big payoff if things go great? And, maybe more importantly, who loses their shirt if things go south? And last but not least, we have the multiple test. Now, this isn't really a brand new test on its own. It's more like a mashup of all the others. The court basically takes a step back and looks at everything together. The control, the integration, the money, to get the full 360-degree view of the relationship.
Okay, so theory is one thing, but let's see how these tests actually work in the real world. We're going to start with a case about a toddy tapper and see how that integration test plays out.
So here's the rundown. You've got this toddy tapper. He's a member of a co-op society. He doesn't have fixed work hours, and he gets paid based on how many bottles he collects. Pretty standard stuff. But then he falls from a tree and gets injured. And that's when the big question hits the court. Was this guy his own boss, or was he an employee?
The verdict? The court said he was a workman, and they used the integration test to get there. The reasoning was simple but powerful. His work wasn't just helping the society's business, his work was the business. Tapping toddy was the whole point, so he was clearly an integral part of the operation.
All right, let's switch gears and look at another case. This time, we'll see the economic reality test in action. This one's about a taxi driver.
So, check out this situation. The driver gets a third of the day's profits, not a flat salary. And he has to pay his own traffic fines. Sounds like a contractor, right? But hold on. The owner pays for all the big stuff, like car repairs and maintenance. Plus, the driver had to report for work every single day.
And this is where it gets really telling. The court said, and I'm quoting here, the respondent neither owned the assets nor bore the risk of loss on the investment. What does that mean? It means the judges zeroed in on who is really on the hook financially. The driver wasn't risking his own money on the car, the owner was.
And that was the clincher, because the owner took on all the major financial risks, the car, the repairs. The court decided the driver was an employee. That profit-sharing deal, that was just a clever way to pay him. At the end of the day, he wasn't running his own business.
Okay, so what happens when the contract says one thing, but what you do every day says something completely different? This is where it gets super interesting because it shows just how far the courts will go to find the truth.
Let's look at the famous Celtel case. On paper, this guy was a consultant. He signed a consultancy agreement, he got a monthly retainer. Sounds official, right? But the reality on the ground was totally different. The company issued him a service certificate, he was using their office space, and get this, internal memos were actually calling him an employee. In the verdict, you guessed it, workman.
This case is a perfect example of a really important legal principle. The courts will always, always look at the reality of the situation over what the piece of paper says. The label doesn't matter as much as the truth of the relationship.
And hey, this isn't just a one-off thing. It happens all the time. We've seen courts do this for all sorts of jobs. Newspaper correspondents, head cutters at tailoring shops, insurance agents, you name it. They consistently use this toolkit to see what's really going on, no matter what the contract claims.
So what's the big takeaway from all these cases? It's that there's no single magic bullet. It's not just about control or just about risk. The courts look at the entire picture. But that brings up a huge question for today.
And this is the really big, crucial question we're left with. We're now in the age of the gig economy, right? With e-workers, on-call workers, online platforms, the whole shebang. So are these tests, which were developed decades ago, still up to the job? Can they handle the complexities of the digital world of work? That, right there, is the massive challenge facing the courts today.